Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone that may be watching online through Nellis or YouTube. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray. Assemblywoman Hanson.
Here.
Assemblywoman Hardy. Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby. Assemblyman Ortliger.
Here.
Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here. And with that, please mark Assemblywoman Bilbray Axelrod and Assemblywoman Cohen absent excused, and please mark Assemblyman Gray present when he arrives. He is on his way. And with that, just a few reminders, if everyone could turn off any of their electric devices so that we're not making noise throughout today's meeting. Also, we will have public comment at the end of today's hearing, and always a good reminder to make sure that any documents or presentation materials that you're preparing for your presentations, please make sure you have them into our committee by 12 p.m. the day prior to your scheduled presentation. With that, we have two bills today scheduled. The first one we will hear is Senate Bill 410 by Senator Orenshaw, and this is a measure revising provisions relating to juvenile justice. So I also see that we have Mr. McCann coming as a co-presenter.
Good morning, Chair.
Do we also have Mr. Rogan with you?
Mr. Reed, if you'd like to come up, I'd love to have you up here.
I have him on the list, so it's all completely up to you, Senator.
I think that would be awesome because this,
We love to,
thank you, Chair. And I think that it's great because this 410 first reprint is the result of a lot of collaboration between Mr. McCann, Mr. Rogan, and myself. Senate Bill 410 has to do with...
let me officially open your hearing.
thank
Your
you.
hearing is officially open.
Thank you, Chair. For the record, James Orenshaw, I represent State Senate District 21 down in Southern Nevada. Thank you for hearing Senate Bill 410, Chair and Committee. It's always great to be here. Served on this committee every session I served in the Assembly, former Vice Chair of this committee, and got great memories of serving on this committee and serving with you, Chair. 410, Senate Bill 410 has to do with what I believe is essential fairness in the workplace. Any one of us could be accused of a crime or of wrongdoing, and it's not always that the person's guilty. Senate Bill 410 has to do with someone being able to have that opportunity to clear their record, not have their career ruined, and be able to clear their name. In many cases, charges may never be filed, or the person may fight the charges and prevail. I'm reminded of a case I had when I first started out. My day job is as a public defender, and a case I had many, many years ago was a case involving an undercover car theft, where a car had been set to look abandoned, but it was full of cameras and microphones to try to catch someone who tried to steal it. And, someone eventually looked at this car and said, that car's just sitting there. I'm going to try and steal this car. And the officers didn't catch the person in the act, but they had tons of video of the person, and I ended up representing the client who was arrested later on because the officers were 100% sure that this was their man. This was the person who went in that car and took the stereo out. And my client was adamant, no, absolutely not. I didn't do that. I wasn't the person. And on the video, there were a lot of similarities. Looked very similar to my client. There was one thing, though, in the video. The gentleman in the video who went in the car to take out the stereo was wearing a shirt with no sleeves, and he had tattoos all up and down his arms. And I'm talking with my client in the office. He was out of custody. And, he was wearing a long-sleeve shirt that covered up his arms. And he said, yes, I know that looks like me. Yes, he's got long hair. Yes, the same kind of build. Unbuttoned his shirt. No tattoos on any of his arms. So even though police prosecutors were 100% sure that this was their man, this was their person, they'd made a mistake. And when I was able to show that to the prosecutor, eventually the charges were dismissed. But if you think about that scenario and think about someone's career possibly being ruined, that's why Senate Bill 410, I think, is so important. This bill applies just to Clark County. to the Department of Juvenile Justice. I've been very lucky to work side by side with a lot of the officers in the Department of Juvenile Justice Services as a public defender in the juvenile division. And a lot of the officers there work with children who've just been arrested. So if you can imagine back to our teenage years, being 14, 15, and being arrested, being in a juvenile detention center, and how scary that would be, I've been so impressed by how so many of the detention staff, the probation officers, are like mentors, are trying to be like an uncle, like a parent, like an aunt to these children and try to reassure them, you're gonna get home, you're gonna get through this, you're gonna be all right. So really some wonderful men and women who work there with the children. And I think Senate Bill 410 is important for any employee. This bill is specific to Department of Juvenile Justice Services to try to correct an issue that was brought to my attention of trying to give those employees the time they need to clear their name and to make sure that if charges aren't filed, if they fight the charges and prevail, that their career won't be ruined. This is a reprint. We worked on an amendment together with Clark County, with Mr. Rogan, with Mr. McCann, and this is a product of collaboration. With your permission, Chair, I'd like to turn it over to Mr. McCann, Mr. Rogan, and then I'm happy to try to answer any questions.
Good morning, Madam Chair, members of the committee and staff. My name is Rick McCann, Nevada Association of Public Safety Officers and member of the Nevada Law Enforcement Coalition. Just for the record, I don't have any tattoos, so that was not me. I think I had to say that. First, I wish to thank Senator Orenshaw for sponsoring this bill. Senator Orenshaw, as many of us know, has always been a champion for juvenile justice issues and the hardworking women and men who work in that environment. Existing law, which is NRS 62G.223, states that a Department of Juvenile Justice Services shall secure appropriate law enforcement agencies' information, background, personal history on people who are applicants for that particular department, or if they are in fact working at that department. And 62G.223 lists about 14 or so criminal acts that they're looking to see if people have committed or been charged with. This investigation, quite frankly, is supposed to be performed about every 5 years. It's a cool thing because we're dealing with kids, so we probably should be looking at that on a pretty routine basis. We've got no problems with that. That's existing law. Existing law, which is again 62G.225, states that if an applicant or an employee has been convicted of one of those crimes or has had a substantiated report of child abuse or neglect made against them, the Department of Juvenile Justice Services shall deny employment to the applicant or terminate the employment of someone who's already employed there after allowing the applicant or the employee time to correct their file. Because quite frankly, some of the information that comes forward on these background checks may be inaccurate. And that gives them a chance to do that. The same statute, 62G.225, states that if an applicant or an employee has charges pending, not a conviction, but charges pending against them for one of those enumerated crimes, the Department of Juvenile Justice may deny employment to the applicant or may terminate the employee after allowing the person time, as set forth in the statute, to be able to correct the file if they can do so. Existing law, 62G.225, states that if an employee has pending charges against them for one of those listed crimes, the Department of Juvenile Justice Services shall allow the employee a reasonable time of not more than 180 days, calendar days, after the arrest to resolve the pending charges and to correct that process if they can. The Department of Juvenile Justice Services may allow the employee additional time. They have the discretion to include additional time to resolve those pending charges if they see fit. Now, the problem and the issue that this bill seeks to remedy is that sometimes it takes an arraignment on a misdemeanor matter many months, sometimes many more than 180 days in the current statute, to be filed, which means the statutory opportunity to clear their record by concluding their charges is really meaningless if they can't even start the process until a misdemeanor arraignment has been concluded, and that may take more than the 180 days. In all fairness to the county, I'm personally aware of many times when they have in fact exercised their discretion to extend that time, and they deserve some applause for that. But there are times when they do not. And SB 410 in front of you, section 1, subsection 4, keeps the current time, excuse me, at 180 calendar days from the date of the arrest to clear their record. That is not changed. But subsection 4 now requires the department to extend that time if the charge is a misdemeanor and through no fault of the employee, the charges or the arraignment has not yet been filed. Section 1 sub 5 also states that the employee may use his or her accrued leave, which would be sick leave, vacation, comp time, whatever, to keep getting a paycheck while they are working to correct their file, because they may be put on administrative leave. So everything's working real well. We've got kids that are concerned. There may be a charge, there may be a criminal charge out there. We have to give these people time under the current law to be able to correct that process. But the problem is, if we're going to give people an opportunity to do so, as the statute requires that they be given that opportunity, we got to give them enough time to do it. And if there's been a substantiated report of child abuse or neglect from an administrative agency, we are, by this statute, or by this bill, not starting that time to run until after the appeals are exhausted. In other words, we have already recognized for many years that you have that time. This bill's not giving that time. That's already there. We're just saying that if situations come about which prevent you from being able to fix your record, conclude your file, like an arraignment that doesn't come for many, 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 many months, that should not be your fault. And this is simply giving that extension an opportunity to work. The well-being of the child is utmost to everyone. So on that, please be aware, because this came up on the Senate side. It was an excellent question by one of the senators, and I want to address it here. During this period, when an employee seeks to correct information to resolve their pending charges, the employee shall not have contact with a child, relative, or guardian of the child while performing any duties. If you want to look at it, it happens to be in Section 1, subparagraph 5A of the bill. It's already there. We think it's important that you know that going in. I can also offer you, that's why the guy on my right is sitting here, we've had Clark County has worked with us to come up with this reprint, and we thank them, thank Mr. Rogan and the county for their professionalism and their understanding of our needs in coming to this resolution. And Madam Chair, with that, those reasons, we ask that you and your committee support SB 410. Thank you.
Thank you. Mr. Rogan, are you just here supporting, answering questions, or did you have any comment?
Good morning, Chair. Jeff Rogan, on behalf of Clark County, I'll just answer any questions that may arise. Thank you.
Thank you. Okay, our first question, you're ready for questions, Senator?
Yes, Chair, thank you.
Our first question will be from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for coming in to present this. It's nice to see you twice in 1 week, Senator. My question is, if this is about workforce fairness and fairness for our employees to be able to correct their record, which I completely understand, why are we applying it only to this one department? Wouldn't this be something that we would want for other employees as well?
James Orange, State Senate District 21, through you, Chair, to Assemblywoman.
Please go direct.
Oh, well, thank you. Assemblywoman Lou Hatch, I don't disagree with you, but Senate Bill 410 is a product of conversations I've had with Mr. McCann and representatives there in the Clark County Department of Juvenile Justice Services. And so certainly I think that it is specific to a certain group of employees where an issue arose. And of course, different employers may not have the same kind of policies. It may not be governed by these statutes. So while I think in principle, every employee should be able to clear their record if they're accused of a crime, accused of child abuse or elder abuse, and they appeal, if there is a finding of substantiation, they appeal that. I believe everybody should have a chance to clear their record. However, this bill is specific to a problem that was brought to me regarding Clark County Department of Juvenile Justice Services.
Madam Chair, if I may offer some additional comment. Thank you, Rick McCann, for the record through the chair. Assemblywoman,
Direct.
Pardon me?
Please go direct.
Sure. There's a pop cap. When this thing came around in about 2011 or something of that nature, they put a pop cap on it of 700,000 people. I can be a smart mouth and say, apparently we don't care about our Washoe County kids. That's dumb. But why they put that pop cap on it, I was not involved in that point in time. But we are dealing with a statute right now, the 62G, that does deal just with Clark County. I don't disagree with you. that the premise upon which this bill is out there, perhaps in the future, should be looked upon in other areas. But I'm not going to make any comment upon that because people want to take me out to the woodshed if I do. But I don't disagree with you. But right now, understand that there was a pop cap put on this on day one, which really is just limiting it to Clark County at this moment.
Which I have the same concerns about it. I don't understand why there's a pop cap on this. I mean, we have professionals and we have these types of situations everywhere throughout our state and additional professions that would stretch not just to law enforcement, but to teachers, to nurses, to counselors, to social workers, to, you know, people professionally are vulnerable to accusations, and there are many accusations out there. So, but I understand based on this chapter and based on this instance, that's why it's specific to this bill.
And thank you, Chair. James Ornstall, Senate District 21. I agree with you on that. I'm certainly not adverse to the idea that these protections should extend to all employees. And if there's an appetite for that, I'm certainly open to listen. If the committee and the other stakeholders, so far no one from any other counties have approached me about wanting to be included in this bill in terms of other associations of the employees who work in these departments. But if that's the appetite of the committee, I'm happy to entertain it and see if that's possible.
Sure, and Senator, we can have those discussions afterwards as well, because now it would also depend on chapter and germaneness and all that kind of stuff. But I think the bigger point is that the position of the committee is that we understand this extends to other professionals, or it should be extended because of the same vulnerability to other professionals as well, so.
And Chair, I agree with you. I think anyone who's accused of wrongdoing should have a chance to clear their name and not have their career, scuttled, especially if, like my client, it wasn't him. Everybody thought it was him, looked just like him in the video, and it wasn't him. And everybody was wrong. And luckily, the charges were dismissed. But, that can happen. And I believe everybody should have that protection.
And it does happen, and sometimes the narrative is worse. Once that narrative is out there, it doesn't matter when your name's been cleared, that narrative is out there. So thank you, I appreciate that. Our next question is from Assemblywoman Mosca. I wrote something completely different down.
Thank you, Chair. No problem. Thank you so much for this. Thank you for answering the question about why Clark County. And then I also had a question around what is the frequency this is happening? So if you want to just talk about the context, and so we have on the record other examples.
Thank you, Rick McCann, for the record. We have someone who's going to be testifying here momentarily, I think, in support, who happens to be a juvenile justice probation supervisor, who may give some additional facts relative to the time it happens. In my experience in representing these people for decades before I retired at the end of 21, there was a few. They're not every day. These are good people, but sometimes someone might have a misdemeanor DUI. Something of that nature, which is on that list. That will be a misdemeanor. They may do something, and it happens occasionally, not frequently, but occasionally. I couldn't give you a specific number. If it was that frequently, I think we'd have a whole different discussion about who these people are. These are good people. They're well-meaning people, but sometimes people make mistakes, and this is giving them an opportunity of doing that. But I don't want to dodge your question, ma'am, but Mr. Richardson may give you some additional feedback on that, but I don't think it's a large quantity, but it does happen on occasion.
Thank you. Our next question is from Assemblywoman Gallant. It's not working?
Oh, now it does. Sorry. Thank you, Chair. So I'm curious about at the time that there's an accusation, they have to kind of wind their way through the legal system. It states here on the fourth page, line 8, that may use his or her accrued leave or be placed on leave without pay. Are there any kind of back office positions in which somebody could use just temporarily be in so that they're not losing pay, they're not having interactions with youth, or because if somebody's innocent, I wouldn't feel so good about using it up my vacation time or not having an income for 180 days. That can put somebody in a really tough position.
Rick McCann for the record. Thank you for the question, Assemblywoman. It depends upon the needs of the employer as well, with the opportunities they have available. I'm pretty confident that the county would, if they could, place you somewhere behind the scenes to do what you got to do so you continue to make a contribution to the department. Remember, you can't have contact with the kids. We know that. And most of these people have contact with the kids. That's what they do. And it's not like a police department where they have evidence vaults and they have other things and you can sit out there and, answer the phones and whatnot. It's not quite that way. I wouldn't suggest to you that that is something that's available to the county a lot, but I'm confident in my relationships with the county in the past that they would do that if they could. I just don't know if they can. And once again, I would defer to Mr. Richardson, who is actually an employee in that capacity, to come up here in a moment, maybe address that.
And that also brings additional questions when it comes to collective bargaining. And so where does collective bargaining come in? Because if they're still a county employee, there should be someplace in the county because they're still technically employed by the county. So
Rick McCann for the record. I would love that the county, as big of an organization and employer as it is, could find a place for everybody. That's not the way it happens. Usually they don't want to take people out of their bargaining units. They don't want to take care of people out of their stuff. And quite frankly, there's an issue of competence to do a job. That would suggest that people can just be placed anywhere, and people are good at their jobs, are trained, they're doing that.
So they can with the police department, but not with the county?
Well, the police department, Rick McCann for the record. The police departments, I don't think, are necessarily known to all of a sudden take police officers and putting them into other county positions.
No, but you said that there were other positions in the police department that they could be placed in, like they could be put into records, they could be put into communications, they could be put into evidence vault. So I'm just wondering.
Rick McCann for the record. If there's availability, we also have that with people who are hurt on the job, people who may be on light duty, who go to different capacities. And those of you on the dais here who have worked with cities or counties and whatnot, you know that that's going to be up to whatever availability there would be. In terms of saying the county is one big employer, therefore we can put people in certain specialized capacities anywhere in the county, which is, I don't think that's what you're saying, but that's harder than you may think. And from a collective bargaining standpoint, usually you don't want to be working outside of your class anyway.
I'm just wondering, where are the collective bargaining units pertaining to this bill?
Well, the collective bargaining units pertaining to this bill, I'm not sure what their relationship would be. This bill is a statutory requirement under the NRS 62G to give these time frames to these people who are juvenile justice probation officers under the department itself of Juvenile Justice Services. The collective bargaining agreements, they may give them certain rights under Peace Officer Bill of Rights, 289, things of that nature. There are rights given to them in that process if they happen to be under here. There are certain time frames that we would observe under that as well.
Yes, I understand that, but the Assemblywoman's question was the availability to be in another position, to be able to continue to work instead of having to burn through all of their personal and vacation time, especially if they're found to be not guilty. So it's kind of like it's not fair that as that person that was accused, so we're trying to see what can the employer do to, or maybe is it the employer then replenishes the that vacation and accrued time. I see heads nodding. And again, that would go back to a collective bargaining agreement. So we're just considering the employee. We're focused on the employee right now. So, which again brings in collective bargaining.
Rick McCann for the record, excellent point, that latter part. There is a statute right now that says, under NRS 289, that if in fact you are found to not have been guilty of this stuff, and there was not disciplinary action pending and whatnot, you'll get this stuff back. So there is that pending. It's not a collective bargaining process. That's actually what the NRS statute is. That's why I was looking at not as a collective bargaining issue. We have law that provides for that, actually from the last session in 2021, I believe.
All right, next question from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you, Senator Orenshaw, for this bill. I had a question on your subsection B regarding the substantiation of report of child abuse or neglect pursuant to 432B. And, looking at 62G and the list of all of the different crimes that are there that they would be looking at, I'm wondering why the bill specifies just that particular offense for additional time versus any of the others that are already listed. That's part one. And then part two, in 62G, I actually don't see 432B referenced in terms of one of those crimes that they're looking for. So if you could maybe address both of those questions.
Thank you, Assemblywoman Newby. James Orenshaw, State Senate District 21. As I look at 432B.317, there's the appeals process. If there's a substantiation of an allegation of child abuse or neglect, which at this point would not necessarily be a criminal allegation. This would be an abuse and neglect allegation through DFS. The appeals time provides that you have 15 days to file your appeal. But as I'm looking through 432B.317, I don't see a time at which a decision has to be made. So that's where I think the employee who's fighting this may really be waiting for a while to get that result of the appeal. Did they win or did they not? So I believe that's why we refer to that statute there. If someone is trying to fight that, and that may not be a criminal charge, that may be an allegation of abuse and neglect that is civil matter through DFS. And if there's anything else, I didn't explain well enough, I'd prefer to jump in.
Rick McCann for the record, if I may, Madam Chair. Further clarification, look at this as criminal elements under 62G 223. You also have administrative charges that can come through the Department of Family Services could be substantiated and provide a different appeal process. The reason why we put it in this statute is it was not lost. We understand that our folks may very well suffer one or the other. And to just make it about the criminal stuff, which is the sexy stuff we talk about all the time under 62G and all the criminal stuff, but there are in fact the administrative charges as well that could be substantiated criminal charges and require under 432B a separate process, a separate appeal process, and a separate determination. And once again, I think Mr. Richardson, who'll be coming up here shortly, may be able to address that because he was in fact involved in that at one point in time.
Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you, Senator Orenshaw. It's always wonderful to see you, gentlemen that are supporting him, Mr. Rogan and Mr. McCann. So I'm curious, just sort of continuing on this questioning about other employees. So the law applies, if I'm reading this correctly, to anyone who works with children, that they have to have a background check, and if there's any kind of a charge, that they are removed from that. But this only seems to help me understand, does this particular suggested legislation only apply to the probation officers in the same department? Like other people work in probation with young people, but this only seems to be for officers. Am I reading that correctly?
Rick McCann for the record, through the chair. Yes, the statute itself under 62G.223, which talks about the background investigations, it deals specifically with Department of Juvenile Justice Service employees. Now, from my perspective, having represented the POs, the probation officers and probation supervisors, that's largely what we've dealt with. But I think I can probably state, and perhaps the county can correct me if I'm wrong, that it would be any individual who works within the Department of Juvenile Justice Services. Questions have come up sometimes, well, does this deal with DFS? Department of Family Services. I don't know that they are actually members of the Department of Juvenile Justice Services, and therefore it may not apply to them. But the statute, as it was written a decade or so more ago, does deal with the Department of Juvenile Justice Services and the people who work within, and most of those people, from my perspective, have been the POs and supervisors as well.
Yes, Assemblywoman, follow up.
Thank you, Madam Chair. So I'm going to paint you a little picture and you help me understand. So I am an employee of the Department of Juvenile Justice Services. I am a secretary or an administrative person. Does this apply to me?
Standing, Rick McCann for the record, standing corrected if I'm wrong, I would believe it would, because you would be an employee of the Department of Juvenile Justice Services. My focus being on POs does not necessarily make it not applicable to other groups. That's my view. I could be wrong, but that's my view, ma'am.
I guess that's maybe where we're having some confusion, because if you're saying it applies to all employees in the department, and the Assemblywoman just asked specifically about a secretary, for example, that secretary doesn't necessarily have contact with the youth. I mean, there's positions that actually don't have contact, so they're not under the same vulnerabilities as a probation officer or a counselor or a therapist or someone that's actively working with the youth. That secretary may not ever see anyone. So I guess that's what we're trying to clarify. Can we get, do we maybe need a legal to respond for us? I guess we're trying to first get to who is protected and why. Is it just professionals that come in contact with youth, or is it everyone in the department? Although we know not everyone in that department would have contact with youth.
Chair James Orchall, State Senate District 21. Certainly, as I read the plain language of 62G.223, I believe that the current statutes apply to every employee of the Department of Juvenile Justice Services in a county over 700,000. And these proposed additional protections would also apply to every employee of that Department of Juvenile Justice Services in a county over 700,000 population, which is Clark. Certainly, I think that the language that Mr. McCann referred to on page 4 of the bill, the existing statute here at 5A of 62G.225 about someone who's trying to clear their name, not having contact with a child or a relative, would be redundant in the point of an employee who's maybe a clerical employee who doesn't have contact anyway. But I think that's there for the employees who would normally have contact to make sure that while there's something pending, that they're not having contact. But I believe, unless I'm incorrect, I believe that it applies to every employee of that department.
Okay. Assemblywoman, does that answer your question?
Madam Chair, it does not, because in page 4, and number 9, it says a peace officer. And so I'm concerned that this is carved out and possibly might not apply to all the folks, because now we have a specific reference to peace officers, and this does give me some concern. Thank you.
James Orchall, Senate 21, to Assemblywoman Summers Armstrong. Certainly, that's not my intent, and if there needs to be a correction, I can consult with LCB on that, but my intent is this would be applicable to anyone.
Madam Chair, if I may, Rick McCann for the record. I would also encourage you to take a look at page 4, subsection 6. If the Department of Juvenile Justice Services places an employee who is a peace officer on leave without pending outcome of the criminal, et cetera. So there, and then we do, in fact, define a peace officer at the bottom, as often our statutes do when we deal with peace officers, because there's an array of statutes that like to define them. But there is a reference there in subsection 6. If the Department of Juvenile Justice Services places an employee who is a peace officer on leave, and that gets back to another earlier question, that if in fact they will award them their back pay for the duration of unpaid leave if, and then there are certain portions of that.
Final follow-up.
So, thank you, Madam Chair. And so, does the reward, reestablishing the leave without pay not apply to any other employee that loses it under the circumstances, or is it just the peace officer who gets their time back?
Madam Chair, Rick McCann for the record. I think it's a very good question. I think that may very well be, and I would certainly defer to legal, but my belief would be that when it does say that if they are a peace officer, these things apply, one could certainly argue that they do not apply to a non-peace officer, which I don't know is necessarily fair, but that's the way the current statute is.
Thank you for that. We have one final question from Assemblywoman Gallant.
Thanks. Thank you, Chair. Okay, I'm just trying to wrap my head around this because I do think that kids need to be protected, and I'm concerned that like I asked a question and now it's like everything's sort of gotten sideways. So, you know, in my original question, I had asked, like, if there's another position where they're not in contact with kids or family, would that be possible? And now we're kind of getting into this, like, mucky area that if, say, a secretary or maybe in the filing, somebody on the back end office, this could possibly apply to them. But if they're not having any contact with kids or family, I would think that it shouldn't apply to them and that there should be time for innocence to be found or not. And then once the final verdict of possible criminal charges or misdemeanor charges, then there could be action taken for back end office that are not in, you know, in contact with kids and family.
Rick McCann, for the record, I don't disagree with you. I do believe we've opened up some cans of worms here that I think are good cans to discuss the fact that, does it apply to non-POs? Probably. If you are a PO, a probation officer, do you get your back pay? Yeah. What if you're not? Shouldn't you get your back pay as well? And I think we've identified certain areas that certainly can be worked upon. I don't have a quarrel with that. I know that that's part of the original bill, or excuse me, the original language of the statute. It's been around for a long time. But I think we are identifying some areas that, in order to give equity to all individuals who are working in that environment, if this does apply to all employees, shouldn't these all employees have the same protections? I don't have a quarrel with that, personally, which my opinion means nothing, but that's my opinion.
Follow up?
Would you be willing to work on some just changes, some addendums through this so that we can clarify this and make sure that this is all very black and white and not leaving us up to questions?
And James Orenshaw cited 21. I certainly would. Certainly as I read the existing statute, it seems like the potential award of back pay applies to the employees who are just peace officers, and that's existing statute. And certainly I think that should apply to everyone. And if all the stakeholders are on board, if there's appetite in the committee, I'd be open to try to correct that.
Jeff Rogan for Clark County. Just a couple things I want to point out is that even within the Department of Juvenile Justice Services, we have members of different bargaining units. And so our JPOs have one collective bargaining agreement. Our secretaries are probably SEIU, and they would have a separate collective bargaining agreement, which may address the return of back pay in a situation like this. And I'm not sure. I'd have to go back and look at the current contract to see. And also, to answer another question is, under 5A, it's not required that a person be placed on leave. So if a secretary does not have contact with a child in the course and conduct of their employment, they could still possibly continue to work without being placed on leave, without having to use their accrued leave, and continue to perform their job and receive their paycheck. But if there are questions that need to be answered in this bill, Clark County is happy to work with Senator Orenshaw and Mr. McCann to resolve those.
Thank you. We have a question from Assemblywoman Hanson.
Thank you, Madam Chair. And it's actually just maybe a request. I think we said somebody from Clark County Juvenile Justice is here that was going to maybe testify in support. So if we could ask some questions of somebody who actually works in that juvenile justice, we maybe could get a little more.
And he was going to testify about a certain scenario that he was aware of, so we're not going to have the ability to open up for full questions on him, as he's representing his own experience, I understand, and just standing in testimony.
Oh, okay. Okay, thank you.
Because we actually have the county here, and we have, so
Right.
they should be able to respond to these questions.
Okay, thank you.
Senator?
I appreciate the robust discussion. I'm happy to answer any questions. And certainly it looks like the existing statute does limit that back pay award statutorily to the employees who are peace officers. And I'm certainly open to trying to extend it to every employee in the department, assuming there's the appetite and stakeholders are on board with that.
And we appreciate that, Senator. We know you're willing and will be accessible after the hearing for any additional requests by members, so we appreciate that.
Happy to answer any additional questions as well.
All right, with that, I don't see any more questions, so I will go ahead and open it up for testimony. So anyone, we'll start here in Carson City. Anyone that would like to testify in support of Senate Bill 410? Please make sure that you state your name and spell it so we have it accurate for the record.
Yes, I'm Matthew Richardson, MattheWRICHARDSON. I'm the president of Juvenile Justice Supervisors Association and also the vice president of the Nevada Association of Public Safety Officers. And more importantly, I'm a juvenile probation supervisor. Thank you, Chair and Assembly on Judiciary and Senator Orenshaw for sponsoring this bill and being a champion for youth and officer rights, and Rick McCann for his tireless work. I support SB 410. I currently work every day in a locked facility with the state's most violent and troubled youth, awaiting court hearings, that are awaiting placements, that are awaiting assessments and or certification to the adult court system. We're constantly understaffed and overcrowded. I myself have been affected by this very problem we are trying to address by this bill. I was running out of time waiting to get a fair hearing for an incident that happened on the job. When I finally received a fair hearing, after 5 months and a few days of being placed into the leave without pay status, I was cleared of all wrongdoing within a few hours of an impartial hearing master reviewing the case. However, the time was very close to running out. If the hearing master would have returned the decision in the normal course, which is 30 days, I would have ran out of time, lost my career, and even though I was cleared of any wrongdoing. I was lucky enough to be granted an expedited decision, which is not in the normal course. The problem we're trying to fix here by this bill is the time allotted to receive a fair hearing and decision being adequate. The current language is not enough, and this bill will fix the issue. For statistical purposes, within the last 3 years, there have been 3 juvenile probation supervisors being placed into the leave without pay status, awaiting administrative hearings for incidents that happened on the job. And, hearing some of the questions that the committee had, I just want to address that we have been trying to work on this bill to include all employees over the last few sessions. The county narrowed it down to the officers, seeing how the officers are the frontline direct staff. And I hope that helps. And I want to thank the committee for your time and attention on SB 410.
Thank you so much for your testimony. Is there anyone else here in Carson City that would like to testify in support? Broadcasting, is there anyone on the lines?
To testify in support of Senate Bill 410, please press *9 now to take your place in the queue. Caller, you may begin, caller.
Yes. Good morning, committee. I'm Kevin Eppinger. Kevin, common spelling Eppinger, E, P as in Paul, E-N-G-E-R. I currently work as a juvenile probation officer with the Department of Juvenile Justice Services and also the president of the Juvenile Justice Probation Officers Association. Throughout the years of having this 62G in effect, there have unfortunately been an average of 2 or 3 officers per year that have had to navigate through the process. With one of the officers, unfortunately, running out of time due to the backlogs in processing. Sometimes the Highway Patrol doesn't get around to filing the charges, and sometimes we've had experience with North Las Vegas. This unfortunately puts the officers up against it in regards to the time because of the legal process. No fault of theirs, but it has cost one officer, like I said, their career. What we're trying to do is hope that we can recognize some of the flaws in the bill and garner the support from the committee with providing the additional time that's needed for those officers. So we appreciate if you could support this bill. Thank you for your time.
Thank you.
Caller with the last 3 digits 738, you are unmuted and may begin.
Hello, good morning. My name is Hernan Arroyo, Hernanarroyo. Good morning to the committee and everybody up in legislation. I am a juvenile probation officer with the Department of Juvenile Justice Services, and I support the Bill 410 in regards to everything that's been transpired and said today with Senator Orenshaw, Mr. McCann, Mr. Richardson, and now Kevin Eppinger, who is president of JJPOA, as I am vice president of JJPOA, the Juvenile Justice Probation Officers Association. With my 25 years of experience in seeing my fellow officers, whether they made a mistake or not, but having the due process and due rights come to them, I would gladly support and hope that you all will give us the opportunity to pass this bill. Many situations that could have just been overturned through the courts, but because of delays, and it's not no one or anyone's fault, but just the fact of having that additional time could save that person's job, career, and the money that supports them and their families. So again, I ask, please support, do what you can to help pass the amendments to this bill, and thank you for your time. Have a good day.
Caller with the last three digits 576, please press star 6 to unmute your phone.
Hello, my name is Tina Cole, Tinakohl. I'm the Vice President of the Juvenile Justice Supervisors Association, and I'm a Juvenile Probation Supervisor for the Clark County Department of Juvenile Justice Services, and I'm speaking in support of SB 410. Thank you very much.
Thank you. We appreciate your testimony.
Caller with the last three digits 402, please press star 6 to unmute your phone. Again, caller with the last three digits 402, please press star 6 to unmute your phone. Chair, we seem to be having issues unmuting this caller. Would you like to move on?
Yes, let's move on, and if they're able to get back in the queue at some point, even if we've passed support testimony, we'll still accept them because we understand technical difficulties.
Hello.
Hello?
Yes, hi. May I provide testimony?
Yes, please.
My name is Darren Demaya. For the record, last name spelled Dimaya, and I am a member of the Juvenile Justice Supervisors Association, as well as a Juvenile Justice Probation Supervisor in Clark County. And I would like to provide testimony today in support of Senate Bill 410. To the chair, please.
Yes, please proceed.
Thank you. I'd just like to say that I am in support of the revisions to 62G represented here on Senate Bill 410. And many thanks to the Assembly for hearing my testimony, and to Senator Orenshaw, James Orenshaw, Matt Richardson, and Mr. Rick McCann, too. Thank you. That concludes my testimony in support of Senate Bill 410.
Thank you.
Good morning, Chairwoman and members of the committee. This is Marlene Lockhart representing SEIU 1107. We are calling in support of this bill. And listening to the testimony, I am endeavoring to check to see if our SEIU members are covered for the back pay and the questions that were raised. We do experience quite often our employees being injured in the scenarios that have been identified in testimony. So we look forward to working with the sponsor and the other interested individuals in providing clarification. Thank you.
Thank you.
Caller with the last three digits 402, please press star 6 to unmute your phone. You are unmuted and may begin. Caller with the last two digits 402, you are unmuted and may begin.
All right, grab the food over here. I don't really.
Chair, would you like to move on?
Ma'am, can you hear us? Hello?
Yes, yes. Can you hear me?
Yes, yes, we can. Please proceed.
Good morning. I'd like to thank you guys for having us here. My name is Tyrone Robertson. Spelling is Roberson. I'm calling support the bill. We'd like to thank you guys for taking the time to listen to hear us out and take these things into consideration. A lot of information has been provided. I've heard a lot of questions about it, so please revisit everything and support of the bill. Again, thank you guys, and have a great morning.
Thank you.
If you have recently joined and would like to testify in support of Assembly Bill 410, please press star 9 now to take your place in the queue. There are no other callers choosing to testify in support of this. Apologies, Chair. Somebody just put their hands up.
Okay, thank you. Hopefully it's a person we weren't able to connect with earlier.
That was the previous call, Chair.
I'm shaking my
Hello?
head as if you can see me, but yes, sir. Are you here for testimony?
Yes, sir. Yes, ma'am. Excuse me. My name is Edgar Ortiz, EDGAR-ORTIZ. I'm a juvenile probation officer with the county. Here to provide a testimony of my own. I would say it was November of 2021. I had a pending charge, and my court case was not ready to be heard by the court until March. However, they weren't prepared, so they extended my time for a total of 180 days, which passed the initial 180 days, for them to finally formally file my case to court. And during that time, I had only been employed I've been with the county for 5 years as a part-time at Spring Mine Youth Camp, part-time in the detention center, and full-time as a probation officer recently. So I didn't really have a lot of time. So I had to be on leave without pay, and they were to the point where I got terminated. However, thanks to the help of the Juvenile Probation Association. They helped me get my job back because after, I want to say, close to a year, the charges were dropped and everything was good. So they were able to get my job back. But however, I wasn't getting paid during this full year. Right now I have my job back, but I'm not getting any back pay or anything like that. So it's been tough, but then I know things happen for a reason. I appreciate you guys hearing my testimony, and I hope this helps in some way. I'm in full support of the bill. Thank you.
Thank you so much for your testimony.
There are no other callers choosing to provide testimony in support at this time.
Thank you. So with that, then I will open it up for testimony in opposition of Senate Bill 410. Is there anyone here in Carson City? Not seeing anyone. Broadcasting, is there anyone on the line?
Testifying in opposition to Assembly Bill 410, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you, Broadcasting. Is there anyone here in Carson City that would like to testify neutral of Senate Bill 410? Not seeing anyone. Broadcasting, is there anyone on the line?
Testifying neutral to Senate Bill 410, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Okay, thank you so much. Then I welcome the senator back up for any final remarks.
Chair Miller, members of the committee, James Orange, Senate 21. Thank you for the robust discussion. This reminds me of my good old days serving on this committee when we'd have some very robust discussions under Chair Bernie Anderson, Chair Jason Frierson, Chair Horn, Chair Yeager, and I appreciate all the good suggestions on the bill. I just wanted to comment, one of the callers, Officer Ortiz, who called in, talked about the time expiring before he could resolve the charges and beat the charges and clear his name, and the union being able to help him. He's one of the lucky ones. Officer Kevin Eppinger, who called earlier, I've had discussions with him about officers who the time expired. They weren't able to get that done in time, and they walked away. They walked away from their career. Many of these officers, you wouldn't know they're officers. You look at them, their day-to-day work. You would think they're social workers. They take kids to go do their GED test, try to get a copy of their birth certificates, and get a license, try to get their safe serve so they can work in the culinary industry, and really go the extra mile to try to help kids succeed and not end up arrested again and back on juvenile probation. So I think these protections are important to try to help people get their due process and not have their career be torpedoed due to an allegation that's not true. As to whether they should be extended, I'm certainly open to that idea, and I think we're going to have some discussions after this hearing. So thank you for the opportunity to present today.
Thank you so much, Senator, and I think we appreciate as well that he was still dedicated and committed to that profession and wanted to return after such a trauma. With that, it was good to have you back here in Assembly Judish, and I will go ahead and close the hearing on Senate Bill 410. With that, our next bill today is Senate Bill 289, which revises provisions relating to juvenile justice. It is sponsored and presented by Senator Nguyen, also someone we're happy to welcome back to Assembly Judiciary. So, Senator, whenever you're ready, please proceed.
Thank you. It is reunion day here today. Good morning, Chair Miller and fellow Judiciary Committee members. I am very excited to be back here. It does feel like coming home to a certain extent. My name is Rochelle Nguyen. I represent Senate District 3 in Southern Nevada, or Central Las Vegas. In fact, my district encompasses most of the Las Vegas Central Medical District, including UMC and Valley Hospital that's right down there. Senate Bill 289 does a couple of things, and I want to give you some background that I'm sure you all know. I know several of you sit on the healthcare committees as well, so this will not be new information to you. Healthcare workers are 5 times more likely to experience workplace violence than other employees in all other industries. Healthcare workers accounted for 73% of all non-fatal workplace injuries and illnesses due to workplace violence in 2018. And unfortunately, with COVID-19 pandemic and the aftermath, this has only exacerbated the problem. A study in the September 2022 issue of Workplace and Health Safety showed that a significant number of hospital nurses reported facing increased physical violence and verbal abuse from patients, loved ones, and visitors compared with pre-pandemic levels. The Nevada Legislature first codified protections for healthcare workers in 2003 in AB 53. As the healthcare industry has evolved, the legislation has also been expanded and amended in multiple times in previous sessions to in consideration of additional healthcare workers. For example, in 2013, the law was amended to include medical students, dental hygienist students, and pharmacy students for purposes of enhancing penalties for the crimes of assault and battery to include such people. Mindful of those developments in the healthcare workforce in the last 10 years and increasing incidents of violence against healthcare workers, Senate Bill 289 and the proposed amendment updates to current law reflect the modern healthcare workforce and intend to extend those same protections afforded to other healthcare workers to our behavioral health technicians and aides, students of emergency medical services, and hospital-based volunteers and public safety officers. The bill also clarifies that the protection should extend to the full hospital premises, including those parking lots. Unfortunately, as you've heard many times in stories on the news, you will hear about how incidences of those violence start in those lobbies with those lobby and healthcare workers that are in the front lines, the true front lines, that are not currently protected. And this bill seeks to include those people and show them that we also intend to protect them as well. Senate Bill 289 came out of efforts from the Southern Nevada Forum as ways to look and support and invest in our healthcare workforce. And this legislation will protect healthcare workers and enables those hospitals to work with public safety and law enforcement teams to expand violence prevention and response strategies throughout the premises and to all of staff, not just those that are doctors or medical students or physician assistants, but all of the staff that work in those hospitals. This kind of concludes my remarks, and I'm open for any questions you might have regarding this.
Our first question, thank you for your presentation, Senator. Our first question will be from Assemblywoman Considine.
Thank you, Madam Chair, and thank you, Senator. It's nice to see you here. I have a couple of questions, but my first question is in Section 1, sub C, it carves out other than a resident. It says healthcare facility other than a resident. So 2 questions. What about a group home? Or if it's a licensed group home, does it count? Or if it's not a licensed group home? And then the second question is, for healthcare workers, home healthcare workers that are going house to help people who are at home, are they carved out completely from this bill?
It was our intention to include those, and in fact, I'm looking at that right now, and I know that is the definition for healthcare facility that is located in other areas. Part of the reason we tried to expand this is I didn't want to have to come back over and over and over again. As you can see, we already have to look at this ever-expanding list of people that need these added protections because they are being targeted, because they are in the healthcare field. It was our intention when you look at section, let's see, E, subsection 2, that talks about an employee or volunteer or healthcare facility who interacts with the public, performs tasks related to providing healthcare, and wears identifying uniforms. It was our intention, and if we need to go back and look at that, because I have been working with SEIU to make sure that our home healthcare workers were also covered under these protections. So if that is not the case, I will work with staff to make sure that that is the intent going forward.
Yes, please.
Thank you. And then the second question, I think, is more just to have clarification on the record. I know in the digest, it says in here that the perpetrator knows or should have known that the victim is a provider of health care. But in going over this originally, what popped into my mind is someone who is suffering from Alzheimer's or dementia. And as part of that health issue, they are violent. So in these situations, I would think that they cannot form the intent to be violent. So I'm wondering if these punishments would apply to someone who, but for the issue that they're having, they don't have that intent. I just kind of want to have that clearly articulated. Thank you.
Rochelle Wynn for the record. You know, I've worked in the criminal defense field, and I think some of you may know that this is my 21st year. And I've done a lot of work with indigent services and being a part of that criminal justice system. Unfortunately, you see it goes hand in hand with mental health and behavioral health issues. And they are they're intertwined that it is unable to see sometimes whether or not you are in a mental health facility or a medical facility or you are at the Clark County Detention Center in my line of work. So that's definitely something that I was aware of. This does not change the law when it comes to the ability to form that intent and be able to charge someone with a crime. So if you have someone who doesn't have that competency to make a decision like you had suggested with like an Alzheimer's patient that doesn't have the ability to form even general intent to commit a battery or an assault, they would still have those same protections under the law where they would not be able to be charged. I know there are several prosecutors in the room, and so they would probably be able to answer those questions as well as the case would move through the criminal justice system on whether or not they would be able to even charge those individuals with that crime. And Rochelle Wynn for the record, just to clarify, I know that our healthcare providers and our hospital providers and our staff, they don't see this as a situation where they will be calling on every person who is in a mental health crisis that is seeking treatment in their hospitals. We've had these protections in place for doctors and other medical professionals, and we haven't seen like an overabundance or abuse of people calling doctors or nurses calling on people that are genuinely coming to the hospital to seek like mental health care in an emergency or a crisis situation. So I don't anticipate that adding these additional people, we would continue to see that. But I think it is important to have that consistency and protect not just our educated professionals, but also our professionals that are working in the healthcare space.
Yes, and thank you for that clarification, as well as we appreciate it's not always just coming from patients either. And I think that that's a reality we need to be honest about. It's not just coming from patients, again, going through an episode or withdrawals or just whatever they're going through. My mom was an RN. It's not just coming from patients. Just like I am an educator, it's not just coming from students. So we need to be fully aware of those realities. So thank you for that. Our next question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. My question was, when reading through it, how do we make sure that individuals know that this is a thing so that it also prevents them from acting in such a way, hopefully?
I think you see a good partnership between like the employees and also the hospitals that many of these, I mean, if we're being honest, most of these are taking place in a traditional like hospital or emergency room type setting. And so I think the partnership between those two agencies, and I think I've been working with them during the formation of this language in this bill, they will do their best to make sure that they are working with their security, they are working to educate all employees that there is the ability and that they have safety in their workplace.
Thank you. Our next question is Assemblywoman Gallant.
Thank you, Chair. I appreciate you making the distinction between Alzheimer's, dementia. Somebody who's worked in a psychiatric facility for adolescents, the first day on the job was the first fight I ever got into. And so, we definitely don't want those patients being punished while they're going through these treatments. So I do appreciate that. However, in my experience, which was a long time ago, so things have changed, it was only my interactions with patients that I had aggressive or violent actions. So can you give me some examples of what's actually happening now? Because I do believe that all healthcare workers need to be protected. I'm just curious, like what is the actual problem, and to make sure that it's not really the patients that we're looking at.
I think I'm probably in a better position if I could call someone. I think if I can have. We have a couple of examples here. If it's okay with the chair,
Yes,
if I can
please.
phone a friend.
Yes, absolutely.
I don't want to misstate some of the examples, and I appreciate your question, Assemblywoman.
Good morning, Madam Chair and committee members. Catherine O'Mara, for the record, with HCA Healthcare, we represent Southern Hills Hospital, which has the Behavioral Health Pavilion, Mountain View Hospital, and Sunrise Hospital and Sunrise Children's Hospital. And so to answer the question, in the vast majority of cases, that we are not calling on patients. It's the vast majority of cases are actually not patient-related. And when the violence is a result of the disease state, we do not call Metro for that. Usually the custom is if it is a patient and it is coming from true violence, because that does happen, we call Metro, and then there's a consultation with that person's physician to ensure that it's not disease state before anything happens. But I will tell you that instances of violence have increased over the last several years. I think the senator well stated it in her testimony. It was tough in 2019. It's even tougher today. And we have seen that increase even in our behavioral health setting. So to your point and in your experience, many times it is violence that is a result of mental health or the disease state. But the small percentages of calls that we make, and I'm looking for my numbers here, but I think it was like 1 in 6 in the last couple of years that we've actually called. Those have been determined to be true violence and not from that Alzheimer's or other mental health issue. Does that answer your question?
Follow up.
So is it the patient that is not having some comorbidity in terms of these breakdowns, or is it family members? Is it friends? Is it spouses? I'm wondering who is perpetrating these.
Catherine O'Mara, for the record. It is all of the above. It is all of the above, but where it is a patient, that extra consideration does take place, right, to make sure that it is not coming from an illness. But it is family members. It is, and I know we have 2 members from the Southern Hills Pavilion, hopefully on the line, since we don't have the Las Vegas committee, who can share some of the specific examples. But it is all of the above. And these are not huge numbers, but it's a culture of protecting our healthcare workers and ensuring that all of our healthcare workers are engaged in that. So the other, update that I think the senator well stated was we now have behavioral health technicians and we now have behavioral health aides that we did not have 10 years ago. So I know you're looking for specific examples of when a person was followed out to their parking lot. Those are never patients. Those are always like a family member or sometimes someone who returns that isn't even in the timeline related to when they were either a patient or a family member, right? They come back because they're still mad. So any of those premises, it could be in the cafeteria. And there is some, I know I'm going a little bit beyond your question here, but there are protections in the bill too to ensure that it's someone who's identifiable as a healthcare worker. But right now you could have a behavioral health technician eating lunch with a physician, and if they're both assaulted in the cafeteria, one is protected and one is not. We're happy to follow up with additional specifics if you would like to know more of the cases if our colleagues in Las Vegas aren't able to provide that detail.
And I definitely had concerns about that. And I do believe that there are protections internally. I believe probably when you were working in that industry, your utmost attention was to those patients because they were in crisis, they were in care, and sometimes they were not acting out of violence, but they were acting out of under whatever conditions they were needing medication, any one of those kind of circumstances. And then it kind of goes hand in hand for me, and I see this as multiple areas of protection for patients under these circumstances that go hand in hand to what Assemblywoman Considine had also alluded to, is not only do we have those protections internally that I believe that hospitals, care centers, nurses, doctors, care facilities, they have the interest of the patient and treating them at their very core of what their, philosophy is. But I think we also have those same due process protections if it does escalate into a situation where someone is in fact arrested. So if someone is arrested in that situation for a battery and they can't form that requisite intent to commit that crime and they are found to be incompetent when that crime was committed, they will not be charged as a crime under a criminal process under that. So there are kind of two levels of protection that I see, and that's why I felt comfortable, adding these workers. And the fact of the matter is these protections already exist for everyone else, and I think that was a perfect example. If you're in the cafeteria and there's a physician and a behavioral health tech, one is protected and one isn't. And I think it is a good policy of this legislative body to say that we protect both of those individuals equally.
Thank you, Senator. Our next question is from Assemblyman Gray.
Thank you, Madam Chair. Senator, great bill. I hear these stories literally every day from friends and family that work at Carson Tahoe. And it actually brought this to me just after the session started. And if I had a BDR left available, I was going to put one together. But regardless, great bill. One thing that I noticed that may or may not be lacking, and I think it more goes to intent, what about third-party providers of security guards? They're not peace officers. A lot of them don't have peace officers conveyed on them, and they don't work for the hospital. And I'm thinking about a very specific incident that happened with a patient's family member against a security guard at Carson Tahoe. And I think those guys, they deserve as much protection. I mean, since they're there to protect the staff, I'd just like to know what the intent was, or if they would be covered.
Rochelle Wynn for the record. I think if you look at page 3 and you look at the bottom of the thing, we did change this from, I think it is changed to a public safety officer in the reprint that came over, and that was intended to include them. But also in that new subsection 2, which emulates the section regarding civilian employees or volunteers of law enforcement within that same statute, we had just cut and paste essentially that where we treat with the political subdivisions, when we treat law enforcement volunteers and employees, I believe that they would be included under there. As an employee or a volunteer for a healthcare facility who interacts with the public, performs tasks related to providing healthcare, and wears identifying information or clothing. So I believe that they are included under there. If they are not, I am open to having those conversations to make sure that other contractors, we did have contractor language that was initially included in the drafting. Legal on the Senate side had indicated that they believed that they were included under this and that contractor language wasn't necessary, but I'm open to looking at that further.
Just real quick, follow on, please, Madam Chair. Thank you. I went through each one of those and tried to figure it out, but when I went through officer specifically, they didn't meet that because they have no peace officer authority conveyed on them, nor are they, law enforcement. And I don't think Carson Tahoe Security, since they're a third-party contractor, has anything that identifies them as being their, as part of the hospital staff. That's why I brought it up. I think there might be a loophole there for a savvy lawyer to wiggle through. And there was a security guard that was hurt pretty good up there. I mean, he had a head injury, so.
Thank you, Assemblyman. I'll take a look at it.
And thank you for that question, because it is important to clarify on the record, because hospitals do and healthcare facilities do have a lot of contractual employees that are often there. So thank you for that. Our next question is from Assemblywoman Hardy.
Thank you, Chair Miller. Good to see you, Senator. I'm over here. I just wanted to put it on the record, and Ms. O'Mara kind of alluded to this already, but it does say facility or on the premises, so that would include, as she said, cafeterias, like parking lots, garages, grounds, anything like that. So it's not just inside a room or, inside a hospital, et cetera. It's anything, all of those areas included.
Rochelle went for the record. That's correct. We wanted to make sure that we included all of those premises that are a part of those like healthcare facilities. As she mentioned before, unfortunately, we have situations where people are being followed out to their cars, to the parking lot that is still on the property, and that is continuing outside the facility, like the physical structure.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you, Senator, for bringing this bill. I really appreciate that you're trying to basically close a loophole of these individuals that are getting missed in protections that we clearly intended for our healthcare workers. My colleagues really, I think, touched on the heart of my question. I just wanted to confirm with you, with this new language, hopefully the goal is we won't have to keep coming back and adding people. According to legal or according to your understanding of the bill, should this pretty much cover everyone in the building as far as healthcare? Will we need to come back in 2 or 3 or 4 or 5, 6 years, add someone else to this list?
Rochelle Wynn, I would hope so. But I am not naive enough to think that that is not the case. I will say that should anyone on this committee be looking at this, you'll realize there are so many exceptions now that perhaps it is time to reconsider what we determined to be a battery. Because unfortunately, I think the reason that we have a lot of these extra added protections is because a battery is a simple misdemeanor. A trespass is a simple misdemeanor. Contributing alcohol to a minor is a simple misdemeanor. And so I think there is some intention to make sure that we show that a petty larceny is not the same as battering one of our healthcare workers. So I would encourage all of you to, take a look at this battery statute further in upcoming legislative sessions, as I know I will be as well. But it is my intention, Assemblywoman, that this captures most of our healthcare workers.
And people in a healthcare facility, correct?
That's correct.
Okay, thank you, because I just appreciate the fact that whether you're a custodian, whether you're a third-party security guard, whether you're doing laundry, whether you're just answering phones, again, where we're at, our reality is just you just may catch it because you're there in that building, and so wanting to make sure that all of our employees are protected. With that, I don't see any additional questions, so I will open it up for testimony. Let's start here in Carson City. Whoever would like to come and testify in support of Senate Bill 289.
Morning, Madam Chair and Committee. My name is George Ross. I'm testifying on behalf of HCA in case it wasn't clear when Ms. O'Mara was up here. HCA is strongly in favor of this bill. I do have, and we really thank Senator Nguyen for bringing this bill and your consideration of it. I just want to add a couple of statistics that relate to some of the questions you've asked. At the end of March, the pavilion at Southern Hills, with its 80 beds, had, since its opening in 2019, had 54 cases of assault by patients. Of them, only 9 was Metro brought in to take the patient away, and had been determined that these people were cognitive enough to understand where they were and who they had assaulted. And the others, that was not the case. Another piece of data I'd like to give, which really addresses why this bill is so important. There have been 35 cases in the last 2 years. Of those, 18 were against mental health technicians. And that is exactly who this bill is designed to help protect. So we appreciate your attention and urge you to support this bill. Thank you.
Good morning, Chair Miller and members of the committee. For the record, Dylan Keith, DYLAN-KEITH with the Vegas Chamber, and also on behalf of the Southern Nevada Forum. The goal of the forum is to find bills that are bipartisan and common sense that solve a problem for Southern Nevada, but also Nevada as a whole. We'd like to thank the sponsor for her work during the forum. It is a months-long process, but we do believe that this bill is a perfect example of what we are aiming to do. We see the problem of increased violence towards our healthcare workers, leading to burnout, when they are truly going to help Nevadans, and that is their sole goal. We believe that these protections are absolutely necessary, and we kindly ask for your support. Thank you.
Madam Chair, Jesse Wadhams with the law firm of Black & Wadhams here today representing the Nevada Hospital Association. In deference to all the great testimony you've heard, we are stand in support for all the reasons you've heard.
Madam Chair and members of the committee, Blaine Osborne, Nevada Rural Hospital Partners. We too really appreciate the sponsors for bringing this bill, and we're thrilled to be here in support. Thank you.
Good morning, Donna Laffey with Ferrari Reader Public Affairs, representing Dignity Health St. Rose Dominican. St. Rose is the largest nonprofit hospital in Southern Nevada with 7 acute care hospitals across the Las Vegas Valley. We supported this measure in the Senate and are proud to be here today to support it again. We thank the bill sponsor for bringing this forward, and we urge your support. Thank you.
Can I have you spell your name for the record too, please? Thank you.
Donna, D-O-N-N-A, Laffey, L-A-F-F-E-Y.
Thank you.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association in support of SB 289. We want to thank Senator Nguyen for bringing the bill. Thank you.
Good morning. I wanted to move over so I could see you.
I know.
I always feel like I'm behind the pole. Barry
yes.
Cole, Barrycole. Well, I'm one of the only physicians, I think, in the room. So let me give you my perspective. I am completely in support of SB 289. Thank you, Ms. Nguyen. You really have done something good. My mental health technicians at the state hospitals have been whomped on. I mean, seriously beaten up. And when I used to have to do the staffing, it was tragic that I could look at where we had injuries, and it was always the frontline staff. I wish I could say it had been some of the psychiatrists, but they had enough sense to go hide in their offices when anything bad was happening. And I don't mean that as an indictment, it's just the way it worked out. We live in an era of cyclical violence. Before it used to be PCP, now it's methamphetamine and God knows what else. Yes, there are people with delirium, they are with dementia, they have psychosis. I'm most afraid of the intoxicated manic. That's my greatest fear. When to call the police was a great question, because I've faced this before, where I've called the police, and it's almost like when they stop laughing, they go, well, you work in a mental hospital, what do you think's supposed to happen? So I've said, well, wait a minute, there's a difference. Violence in the context of mental illness is very understandable, but violence when it's not appropriate, that's a problem. One of my residents was cold-cocked for no reason whatsoever. He held the door open for a patient after we'd had a treatment team meeting and was socked in the face. Another resident had her head beaten on the concrete floor to the point where she's now having permanent amnesia for that period of time. Yes, we need to protect everybody in the hospital. I don't care who you are. If you're on the grounds and you have a badge, you need to be protected. Hospitals are dangerous enough. You've heard of the episodes where physicians and nurses have been shot in parking lots, in emergency rooms. We had a shooting up at Renown 20 years ago. A urologist shot in the office by a disgruntled patient. I had one of my psychologists at Northern Nevada Adult Mental Health shot by a disgruntled husband because we proved his wife was not mentally ill, and he shot her because she was able to make that determination. So anything we can do to protect the people who work in mental health, work in hospitals, it's absolutely needed. And I want to just give you the last tip of mental health.
Yes, please, doctor.
Mental illness explains behavior. It doesn't excuse it. And that's a big difference. So I thank you for your attention.
Thank you.
Good morning, Chair. Good morning, Chair Miller and members.
Assemblywoman is timing you, so no.
I'll do my best to keep it brief.
Although on Friday, it's rarely necessary. Like all of a sudden, the testimonies are like, hi, it's me, we support it, bye. So keep going, Mr. Rogan.
Thank you, Jeff Rogan, on behalf of Clark County and the University Medical Center of Southern Nevada. I do want to give extra special thanks to Senator Wynn for bringing this bill, since, as she mentioned, the premises of the UMC are located within her Senate district. UMC and Clark County are in support of this bill. We do think, as Assemblywoman LaRue Hatch said, that this closes a loophole and makes clear that it's not just doctors and physicians and people with RN or DO after their name deserve the protections of our criminal code, but anyone who's working in a healthcare facility or on the premises of a healthcare facility. And that would include security officers. It would include what we call our concierges at UMC. And oftentimes those are the people that have the first interactions with people when they come onto the hospital premises. And as you know, UMC has does have the only level 1 trauma center in Southern Nevada. So we get a certain category of patient, oftentimes resulting from criminal activity. And with that comes other people onto our premises who are oftentimes can be quite hostile, not just to medical healthcare providers, but our staff, our volunteers. And we do have incidents that result from those types of interactions. And so this bill would close that loophole, provide those protections for those employees and volunteers. And so for that reason, we urge your support of this important bill. Thank you.
Good morning, Chair Miller and members of the Judiciary. My name is Beth Schmidt, SCHMIDT. I'm testifying this morning on behalf of the LVMPD, the Las Vegas Metropolitan Police Department, as well as the Nevada Sheriffs and Chiefs Association. We do support SB 289 wholeheartedly, and my colleague Jeff Rogan has very eloquently stated, I want to say that I agree with everything he did say, especially what occurs at UMC. We truly appreciate you, Senator Wynn, for bringing this forward. We support all efforts to protect the folks that do work in our healthcare facilities in the state of Nevada.
Thank you so much. Is there anyone else here in Carson City that would like to testify in support? Broadcasting, will you open the lines for anyone wishing to testify in support?
To testify in support of Senate Bill 289, please press star 9 now to take your place in the queue.
Thank you, Chair Miller and members of this committee. My name is Jill Goodman, JILLGOODMAN, and I'm the Director of Nursing for the Pavilion at Southern Hills Hospital. I learned about the statute, SB 289, after a patient without provocation assaulted and injured a mental health technician. We did call Metro Police Department. When they came, we were told that the mental health technician was not a protected person under the statute and that they can only do a report and a citation. If the patient had assaulted the nurse standing next to him or a physician, that patient with the injuries that were sustained to this technician, the patient would have been charged. Any person working in the healthcare and providing care to a patient should be protected under this statute. Mental health technicians are providing continuous monitoring for safety and assisting with the recovery of all of our patients. I know that you heard some of the stats that were given earlier, but we did in the Southern Hills have 86 employee assaults from March of 2019. These are all documented by our employee health department. 54 of those assaults were from the pavilion. Only 9 of them were removed from the facility with the assistance of the Metro Police Department. The assaulted behaviors were not related to the mental health conditions or diagnoses, and these were reviewed by the psychiatrist prior to moving anything forward with the removal of these patients from our building. Recently, we also had a patient who targeted one of our mental health technicians while they were here in our building. The patient returned to our facility after he was discharged and stood at the employee entrance of the pavilion on the night shift to find that tech. Another staff did recognize him as a patient who was recently in our building and called both security and Metro. The patient fled when security arrived, but we all know that this situation could have been very different if that patient had not left and had been seen by another employee. I asked this committee to understand the necessity to expand the NRS statute to include not only mental health technicians as a protected person, but to also extend the healthcare premises of the healthcare facilities, including our parking lots, in which all of our workers come in and out of. I thank you for listening to me and considering this is an important matter.
Thank you so much.
Thank you, Chair Miller. Thank you, Chair Miller and other members of the committee. My name is Kenny Monkel, M-O-N-K-E-L. I'm here today representing Hospital Corporation of America, also known as HCA. I work at the Behavioral Health Facility at Southern Hills Hospital, also known as the Pavilion. I currently hold the position of a mental health technician and have been working as one for more than 20 years. I'm here to talk to you about the importance of having statute NRS 200.471 changed. Within the current statute, I, along with other mental health technicians, are not protected if a patient under our care at our facility decides to become violently aggressive and injures one of us. In all my years working as a mental health technician, I have seen many staff hurt, including myself. Some of the staff are attacked so severely that they can no longer perform their job duties and unfortunately must quit their jobs, so they will not be able to provide for their families. As a mental health technician, we are the staff members that spend the most time with the patients while they are in the mental health facility. It's a 12-hour shift. We get to know the patients very well, as we are those to observe and report all behaviors, both good and bad. There are times that patients don't have their demands met and verbally state that they will become physically violent to get their demands met. Unfortunately, more times than wanted, the patient acts upon their threats and violently assaults a staff member. In closing, all staff members should be protected along with the rest of the current licensed healthcare workers that are protected today. As a mental health technician, we are given the opportunity to truly make a difference in patients' lives that are going through some form of crisis. Thank you for your time and consideration, and I greatly appreciate you all.
Thank you so much.
Good morning, Madam Chair and members of the committee. My name is Marlene Lockhart, representing SEIU 1107. We are very pleased to support this measure and thank Senator Wynn for bringing it forward to expand the coverage. SEIU was proud to have legislation, I think about 2 years ago, AB 348, that implemented workplace violence measures and protections for hospital staff and others. And in that bill, it also included physical and facility protections, like picking up chairs and throwing chairs and that sort of thing. And so it wasn't just personal attacks, but included physical safety from equipment. We also appreciate the willingness of Senator Wynn to work with us to ensure that our home care workers are also covered under this measure, and we urge your support. Thank you very much.
There are no other callers to provide testimony at this time.
Thank you for that. I'll open it up for testimony in opposition if there's anyone here in Carson City that would like to oppose Senate Bill 289. Not seeing anyone. Broadcasting, is there anyone on the line?
There are no callers to provide opposition testimony at this time.
Thank you. Then I will open it up for testimony in neutral of Senate Bill 289. Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Broadcasting, is there anyone on the line?
There are no callers to testify in neutral at this time.
Thank you so much. Then I will welcome Senator Wynn back for any final remarks.
Thank you. I appreciate all the feedback. I will continue to work on this, and if anyone has any other thoughts on this after this committee, please reach out to me. I think it is always our intention in this building to try to get it right, and sometimes you need this vetting process more than others, and I take into consideration all of your comments, so thank you.
Thank you so much, Senator. With that, I will go ahead and close the hearing on Senate Bill 289. Our final item on the agenda today is public comment. So if anyone would like to make public comment on anything pertaining to anything other than the two bills that we just heard this morning, please come forward. Not seeing anyone. Broadcasting, is there anyone on the line?
Provide public testimony. Please press star 9 to take your place in the queue. There are no callers choosing to provide public testimony at this time.
Thank you so much. Well, with that, that concludes our business for the day. Everyone enjoy your weekend, and I'll see you back at 9 a.m. on Monday morning. This meeting is adjourned.